classification or the work that falls under your trade. So for example, if you're a painter, you can't put in your advertisement that you also do electrical work. So if you have the C33 painting license, you can't put painting and drywall, because drywall is a different license. You cannot put painting and plumbing, because plumbing is a different license. So you can only advertise for work that falls under your classification. Number two, the second thing I want you to take out of this is, technically, by law, you do not need a license to advertise. However, in every single advertisement, you have to put that you are an unlicensed contractor and you can only do work $500 and below. That includes labor and materials. So yes, you can technically advertise without a license, but in every single advertisement, you have to put those two things: that you're an unlicensed contractor and you can only do work $500 and below. That includes labor and materials. I don't believe you'll get a lot of calls doing that, but that is the law. The third paragraph. Now, this is the third paragraph on page 3. Again, a huge disconnect between us and the misinformation in construction. The third paragraph, please highlight the third paragraph in full. It tells you, if you're working without a contractor license, which means you're self-employed, doing work directly with the client, you have no protections under the law if the client refuses to pay you. It does not matter if you had a contract. You have no protections under the law, which means, yes, you can do an entire project, $20,000, $30,000, $50,000, $5,000 even. If you're doing work without a license, you have no protections under the law, which means you cannot sue them in court to recover your money back, which means you can do an entire project and the client says, well, you don't have a license, I'm not going to pay you. You would literally be without any options. I do not recommend you try to consult a lawyer about it, and the reason for that is because the very first thing that they ask you in the court when a case does get presented is, where is your license? What is your license number? I've been in small claims court with some of our students just to kind of see how it goes, to see what the system is. The lawyer gives you high hopes. The lawyer, well, give me $2,000, $1,500. I believe that we can get this money back. And ultimately, not only do you lose money in the contract because the judge rules in favor of the client, you would also lose money paying the lawyer. Again, the very first thing that they ask you is, where is your license? Now, if the project that you were doing was under $500, including labor and materials, then of course you can sue them in small claims court. But again, anything $500 or more that includes labor and materials, you need a valid contractor license. So if the client refuses to pay you, you have no protections under the law. That's not me agreeing with this paragraph. That's not me agreeing with the way the law is. But I'm pretty sure if you follow us on our Instagram, on our YouTube, you'll see a lot of contractors tell their story and how much money that's been ultimately lost for working without a license. So I'm not here to tell you, oh, well, you're in the wrong. No, I understand everyone needs to eat. I understand that everyone has to feed their families, has to pay their bills. My job is to inform you what the law is and what the possible consequences are for working without the license. And yes, I've been there. I've been to those small claims court, and it never really rules in favor of the contractor, even if the contractor did good work. And the reason for that is because the contractor is the first party that violated the law because they are working without a license. Even if the client says it doesn't matter that you don't have a license. Don't fall for the trap. Get your license, get yourself protected. And in the last paragraph on page 3, I want you to also highlight this paragraph in full, where it tells you all the vehicles used in the contractor's business must have the business name and license number clearly visible in letters at least 3/4 of an inch in height. Unless you're a plumber, an electrical sign contractor, or a well drilling contractor, it has to be 1.5 inches. So this is basically the business name and the license number in any vehicle that you use for the company, whether it be a car, truck, or van. These are the requirements for your business name and license number. So we're going to go ahead and go to page 4, chapter 1, page 4, that very first paragraph. You want to go ahead and highlight that first sentence where it tells you contractors must include their license number in all construction contracts, subcontracts, calls for bids, and all forms of advertising. They must also include the following statement in prime contracts. Okay, so in this paragraph, I want you to highlight the first sentence, and it's pretty much telling you the most important thing and the most common thing that you have to include in all forms of advertising, in all of your contracts, in all of your business cards, and pretty much everything you do as a contractor is your license number. Because if you think about it, it doesn't matter if it's a home improvement, home solicitation, service and repair, a commercial contract, a public contract. It could be an advertisement on Craigslist, an advertisement on Facebook, on Instagram. You have to include your license number in everything you do. And the reason for that is because with just your license number, I can see all your information. If you go to the CSLB website right now, cslb.ca.gov, you can type in a license number of any contractor that you've ever seen before. When you type that license number in, you can see everything. You can see the day they activated the license. When does it expire? Do they have insurance? The name of the company, the address, the phone number. Has anybody submitted a complaint against them? I can see all that information with just a license number. For good practice, what we do as the school on our Facebook, on our Instagram, on our YouTube, we put the license numbers of all of our students that actually have obtained the license. So if you see like some of the videos that have the license number at the bottom, please go to the CSLB website. Please type in the license number. You'll see that they've obtained their license with us. And the best thing about it is it's good practice. The reason why it's good practice is because your clients will verify your license the same way. Other contractors will verify your license the same way. So the biggest takeaway from this paragraph is the most important and most common thing that you have to include in everything you do as a contractor is include your license number. Your license number is by far the most important thing that you have to include in everything that you do. Now, on chapter 1, page 5, these are exemptions. These are some examples of the people that don't require the license. I want you to put dump trucks, 20 days. Pay a dump truck within 20 days. That's it. That's all I want you to remember. You have to pay a dump truck within 20 days. The way they word it is very confusing. I don't know why they word it this way, but I did want to simplify that for you. Dump trucks must be paid within 20 days. Moving on towards the bottom portion of page 19, you have to keep all your records, documents, and receipts for at least 5 years, and that's a requirement through the Contractor State License Board. So you have to keep all your paperwork for at least 5 years. Anything that it's in any way, shape, or form related to your construction business, keep that document for at least 5 years. Failure to pay employees after receiving payment from the client, that's pretty obvious, right? You have to pay your employees, right? They're normally on a payment schedule. They're normally paid every 2 weeks. That's the most common way of paying your employees. So again, at the top of page 19, please put a star. Please study every single bullet point. A lot of those, I will give you some of those on the practice test this Thursday, but I want you to study, please. We're going to go ahead and move forward to chapter 1, page 20. We're going to be at the bottom where it says citations. So in the second paragraph, I want you to highlight that very first sentence where it tells you a citation must be in writing and specify the section of the license law that was violated. So they can't just tell you, oh, you're fine, show up to court. No, they have to give you a written citation with the penal code that you violated. In the third paragraph on page 20, at the bottom where it says citations, I do want you to highlight the first sentence where it tells you a licensee served with a citation may appeal to the registrar for a hearing within 15 working days. So if you receive a citation, you have 15 working days to try to appeal it. And then at the last paragraph, I do want you to highlight that paragraph as well, where it tells you if you've had your license revoked, it may not be reissued for at least 1 year. So what does that mean? Let's say they revoked your license. When they revoke your license, that means it's something very serious. That means you were not following the laws at all. They revoked your license. You have to wait at least 1 year until you can reapply. And even if you were to reapply, it is not guaranteed that they will issue you your license again. So you would have to wait 1 year after it was revoked. And even if you were to apply again, it is not a guarantee that they will give you your license back. Okay, so now we're going to go to chapter 1, page 22. Chapter 1, page 22. We're going to go ahead and B, where it says arbitration. Well, actually, let's go to prevention. That's what I want to focus on right now. Chapter 1, page 22, where it says prevention. In the first paragraph, I want you to highlight the first 3 sentences where it tells you the best way to handle. Well, actually, let's highlight the entire paragraph. So, chapter 1, page 22, where it says prevention. I want you to highlight the entire paragraph in full, where it says the best way to handle a dispute is to prevent one from occurring. One of the most basic ways to prevent a dispute is to put your agreement in writing. I do not know why so many contractors in this state tend to think that verbal contracts are legal, or that they believe that verbal contracts even exist. I don't know who told you that, but please don't fall for that. Verbal contracts do not exist. Verbal contracts, especially if there's no recording of it, there's no way to ensure what the original deal was. Because you think about it, you're trying to go to the court system with the mediator, with the judge, and now it's a bunch of he say this, she said that, right? Don't fall for that. Make sure that you put everything in writing. Even if you're an unlicensed contractor doing work right now, please have a contract. Even though it wouldn't be admissible in court, even though it's not going to benefit you as far as not having a license, obviously you're not going to be protected either way, but at least you have a clear-cut understanding of what the services were for what payment, right? Is going to be what labor, what services are provided, for how much money the client is supposed to pay you. Above all else, you want to be clear and concise with your client. What services are you getting? What services are you providing? For what payment? Please have a contract, even if you're unlicensed. That's going to prevent so much miscommunication between you and your client. Now, in the second paragraph, it says disputes often arise over changes or extras that are added or thought to be added to the job. Go ahead and highlight those 2 sentences as well, where it says disputes often arise over changes or extras that are added or thought to be added to the job. The most reasonable method of preventing disputes about change orders is to discuss change orders with the owner at the pre-construction meeting. Again, it all goes back to the same thing. Make sure you put as much as you can in writing. Please do that. That will prevent a lot of miscommunication between you and your client. And again, you want to detail out what labor, what services are you providing, for how much payment, and when are the payments supposed to be done. Now we're going to discuss arbitration. What is arbitration? One of the most basic ways to prevent a dispute is to put one in writing, so we kind of already covered that. But basically, what I want to really talk about in this portion of the paragraph, arbitration is like a court, right? Within the CSLB, it's a hearing between you and the client and a mediator, which is like the judge. So what I want you to do at the bottom of page 22 is highlight the entire paragraph. Where it says arbitration, highlight the entire paragraph. Again, arbitration is like a court within the CSLB. It hears your side, the contractor side. It hears the client side, and the one in the middle is the CSLB. The CSLB will then try to determine who was at fault and try to find a solution that's best for both of you. Not just one side, but best for both of you. Unless the contractor was extremely guilty of fraud or something of that nature, they will still try to find the best solution for both of you. Okay? What do we have to know regarding arbitration? Now, technically, there's 2 versions of arbitration. What I first want to clear up is whether it's private or non-private. Private arbitration means that it was agreed upon when the contract was signed. So in a lot of home improvement contracts, at the back of the contract, there's a portion of arbitration. You explain to your client there, hey, if there's any problems during or after or before the contract or before the project is even done, instead of going to court and paying the court fees and hiring lawyers, one option we have is going directly to the CSLB and having them hear out our case. So instead of wasting money through the court system, we can go directly to the CSLB. Basically, we go directly to the State Department that issues my license. And again, the CSLB will try to find a solution that's best for both of you, and we'll try to find out who was at fault. The best thing about this is it's free. So why not take advantage of this? The CSLB arbitration program is free. All that needs to be done is your license needs to be in good standing, which means that you can't have a bunch of complaints against your license. So if your license is in good standing, you do qualify for the arbitration program, and it's free, which is the best part of it. If it's non-private arbitration, that basically means that the client contacted the CSLB directly to submit a complaint against you. They would mail out paperwork to your address. You would have to fill out the paperwork and return it within 30 calendar days. Now, what else do we have to know in regards to arbitration? I did say I wanted you to highlight the entire paragraph, because if it's mandatory arbitration, that means that only the client has the option to go or not go. So for example, if the client says, no, I don't want to go to arbitration, then you guys are going to court. If the client says, yes, we are going to arbitration, it doesn't even matter if you say yes or no, you're going to arbitration. So if it's mandatory arbitration, only the client has the option of saying yes or no. If the client says yes, whether you like it or not, you're going. If the client says no, you're going to court. And mandatory arbitration is for $15,000 or less. Mandatory arbitration is for disputes, $15,000 or less. If it's voluntary arbitration means that it's more than $15,000 but less than $50,000. And both parties must agree to go, which means the client must agree to go and you need to agree to go. So remember, mandatory arbitration is $15,000 or less. Only the client has the option of saying yes or no. If it's voluntary arbitration, both parties must be in agreement to go. And again, who are the parties? The client and the contractor. These are the things that you have to know to run your business. So the very first step is the course, studying the materials to ensure you can pass the 2 state exams. The second step of you getting your license is the registration of your business. Remember, we covered that on page 6 already. The California contractor licenses are not issued to you individually. They are issued to the entity that you will register. The last and final step is sending your application to the state. The state charges you $330 in a check or money order to process your application and to give you the 2 state exams. If you were to pass your exams, it's $200 to activate the license, okay? But all this is done in steps. You're not gonna pay everything all at once, right? It's done in steps, just like any project is done in steps. When you do a project, you're not gonna knock it out, right, within 1 hour. You have to, well, depends on the size of the project, obviously, but let's say a new construction project. A new construction project will not be knocked out within 1 day. It takes time. You divide the project into phases. That's the same exact thing with the license. The minimum time that it takes to obtain a contractor license is 3 months. And the reason for that is because the state takes 30 to 45 business days just to receive your application, process it, and send you the confirmation letter. So remember, this is done in phases. You're not gonna do it all at once. Now, if you were to pass your exams, you have to renew your license every 2 years. Again, if you were to pass your exams, you have to renew your license every 2 years. The license will expire on the last day of the month in which it was activated. So for example, if the license was activated November 1st of this year, okay, November 1st, let's say they activated your license. Technically, your license will not expire until November 30th, 2022, okay, because there's only 30 days in November. Let's say, for example, they activated your license November 1st of 2020. Your license will technically not expire until November 30th, 2022. Just to give you guys an example of that. Let's say you were to fail your exams. If you were to fail your exam, you have to pay $60 back to the Contractor State License Board to obtain another test date. Again, if you were to fail your exams, you would pay $60 back to the CSLB to get another test date. Let's say you put your license inactive. There are some people that pass the exams and put their license inactive. Why would they do that? An inactive license simply states that they want the license in case something happens. Let's say in case they get laid off, or in case they just want the license in case something happens. you have the option of putting the license inactive. An inactive license only has to be renewed every 4 years, and it does not require a contractor's bond or a QI. So an inactive license only has to be an inactive license only has to be renewed every 4 years. It does not require a contractor's bond or a QI. An expired license may be renewed within 5 years. So what does an expired license mean? I'm gonna go back to the same example. They activated your license November 1st, 2020. It will not expire until November 30th, 2022. From November 30th, 2022, you would have 5 years to renew it without taking the exams again. If 5 years pass and you did not renew the license, then you have to take both exams again. So from the day that it expires, you have 5 years to renew it without taking the exams again. You have 18 months to pass with the contractor state license board. So let's say, what does that mean? Let's say you go to the state, you fail, you keep going, you keep going, you keep going. You have 18 months to try to pass with the state of California. Your application is valid basically for 18 months with the CSLB. Okay. Now we're gonna go ahead and be on page 11. I want to talk about the contractor's bond. So again, there's a lot of misinformation regarding the contractor's bond. The contractor's bond is also known as the license bond. This is the bond that needs to be purchased to activate your license. This bond is not an insurance. This bond is not to protect you. This bond is to protect your client and your employees. This bond protects clients and employees from fraudulent contractors, which means, let's say you get a deposit from a client to do a job. You decide not to do the work. You decide to abandon the work altogether. You decide to leave, never to see the client ever again. Luckily, the client would have the information of your bond with your license number. The bonding company pays out any damages. Then they will suspend your license. Same thing with your employees. Let's say you refuse to pay your employees. The employees can sue the bonding company that you have. Bonding company pays out any damages. Then they suspend your license. So again, the bond is not an insurance. It's not made to protect you. The bond is simply to make sure you follow the laws, and it's used to protect your client and your employees. Again, this bond is needed to activate the license. This bond must cover you $15,000. Does that mean you have to pay $15,000? No. Does that mean you have to have $5,000, $10,000, $15,000 in the bank? No. This bond only costs $80 to $180 once a year. I'm going to say that again. This bond only costs $80 to $180 once a year. It is not an insurance, even though you can purchase it from insurance agents. But again, this is a bond used to protect your clients and your employees from fraudulent contractors. You want to renew your bond at least 1 month prior to expiration. And this is the most common reason licenses are suspended. A lot of contractors tend to forget that they need a bond or that they have to renew their bond. My best recommendation is you buy the bond for 2 years and you renew it as you renew your license. Okay, so we're gonna go ahead and go to chapter 1, page 15. We're gonna be in the very first paragraph. I want you to highlight the second and the third sentence. We've already covered this, but now I want you to highlight it where it says an active contractor license expires 2 years from the last day of the month in which the license is issued. An inactive license must be renewed every 4 years. So we did already cover that, but I just wanted to show you where I got the information so you can go ahead and highlight it. In the third paragraph on page 15, I want you to go ahead and highlight the first 2 sentences where it tells you an expired license may be renewed at any time within 5 years of its expiration. After 5 years, an unrenewed license becomes void and you must submit a new application to obtain a license. Okay? So now we're going to go ahead and move forward to page 19. Chapter 1, page 19. I do want you to put a star at the very top of this page These are examples of where the CSLB can suspend or revoke your license. I want you to put a star at the top of this page because I want you to study it as much as possible. Every single one of these bullet points are examples of where the CSLB can suspend or revoke your license. But not only that, a lot of these are questions at the state exam. So they're not going to give you all of these, right? They're going to pick out 1, 2, 3, or 4, and they're going to give you these questions at the state. So for example, the first one, abandonment of a construction project without a legal excuse. The CSLB can suspend or revoke your license. You cannot just abandon a project for no reason. That is a clear-cut example of where they can suspend or revoke your license. Diversion of funds. So I do want you to highlight this. This is normally more common in public works, where let's say the public entity, the public department gives you money to purchase materials or gives you money to further along the process of the construction process, to further along the project. If you take some of that money, let's say for example, the public entity gave you $5,000 to purchase materials. You take those $5,000 and you go buy yourself a new car or a new truck or to pay your rent. That is diversion of funds. They can and will suspend and revoke your license. And not only that, if the amount diverted is more than $2,350, the penalty is a fine up to $10,000 and imprisonment up to 1 year. If the amount diverted is less than $223.50, diversion is a misdemeanor and punishable by a fine up to $1,000 and 6 months in jail. So as you can tell, diversion of funds is a very serious problem. If you get money, just use the money to further along that project. Don't take that money and go do anything else with it. That is more common in public works, but I do want you to highlight that as well. The third one is failure of a prime contractor to pay a subcontractor within 7 days of receiving a progress payment. So if you are the prime contractor that hired subs to do a specific portion of the job, as soon as you receive a progress payment, you have 7 days to pay a subcontractor. Failure to do this can result in your license being suspended or revoked. So remember, if you are a prime, you have 7 days to pay a sub from when you receive a progress payment. In the fourth bullet point, where it says dump trucks, I just want you to make a quick note, because if you read the paragraph, it's kind of confusing. I want you to put dump trucks, 20 days. Pay a dump truck within 20 days. That's it. That's all I want you to remember. You have to pay a dump truck within 20 days. The way they word it is very confusing. I don't know why they word it this way, but I did want to simplify that for you. Dump trucks must be paid within 20 days. Moving on towards the bottom portion of page 19, you have to keep all your records, documents, and receipts for at least 5 years, and that's a requirement through the Contractor State License Board. So you have to keep all your paperwork for at least 5 years. Anything that it's in any way, shape, or form related to your construction business, keep that document for at least 5 years. Failure to pay employees after receiving payment from the client, that's pretty obvious, right? You have to pay your employees, right? They're normally on a payment schedule. They're normally paid every 2 weeks. That's the most common way of paying your employees. So again, at the top of page 19, please put a star. Please study every single bullet point. A lot of those, I will give you some of those on the practice test this Thursday, but I want you to study, please. We're going to go ahead and move forward to chapter 1, page 20. We're going to be at the bottom where it says citations. So in the second paragraph, I want you to highlight that very first sentence where it tells you a citation must be in writing and specify the section of the license law that was violated. So they can't just tell you, oh, you're fine, show up to court. No, they have to give you a written citation with the penal code that you violated. In the third paragraph on page 20, at the bottom where it says citations, I do want you to highlight the first sentence where it tells you a licensee served with a citation may appeal to the registrar for a hearing within 15 working days. So if you receive a citation, you have 15 working days to try to appeal it. And then at the last paragraph, I do want you to highlight that paragraph as well, where it tells you if you've had your license revoked, it may not be reissued for at least 1 year. So what does that mean? Let's say they revoked your license. When they revoke your license, that means it's something very serious. That means you were not following the laws at all. They revoked your license. You have to wait at least 1 year until you can reapply. And even if you were to reapply, it is not guaranteed that they will issue you your license again. So you would have to wait 1 year after it was revoked. And even if you were to apply again, it is not a guarantee that they will give you your license back. Okay, so now we're going to go to chapter 1, page 22. Chapter 1, page 22. We're going to go ahead and
in 2 miles, take exit 94 for California 79, Beaumont Avenue.
Well, actually, let's go to prevention. That's what I want to focus on right now. Chapter 1, page 22, where it says prevention. In the first paragraph, I want you to highlight the first 3 sentences where it tells you the best way to handle. Well, actually, let's highlight the entire paragraph. So, chapter 1, page 22, where it says prevention. I want you to highlight the entire paragraph in full, where it says the best way to handle a dispute is to prevent one from occurring. One of the most basic ways to prevent a dispute is to put your agreement in writing. I do not know why so many contractors in this state tend to think that verbal contracts are legal, or that they believe that verbal contracts even exist. I don't know who told you that, but please don't fall for that. Verbal contracts do not exist. Verbal contracts, especially if there's no recording of it, there's no way to ensure what the original deal was. Because you think about it, you're trying to go to the court system with the mediator, with the judge, and now it's a bunch of he say this, she said that, right? Don't fall for that. Make sure that you put everything in writing. Even if you're an unlicensed contractor doing work right now, please have a contract. Even though it wouldn't be admissible in court, even though it's not going to benefit you as far as not having a license, obviously you're not going to be protected either way, but at least you have a clear-cut understanding of what the services were for what payment, right? It's going to be what labor, what services are provided.
In a quarter mile, take exit 94 for California 79, Beaumont Avenue.
Above all else, you want to be clear and concise with your client. What services are you getting? What services are you providing? For what payment? Please have a contract, even if you're unlicensed. That's going to prevent so much miscommunication between you and your client.
Take exit 94.
Now, in the second paragraph, it says disputes often arise over changes or extras that are added or thought to be added to the job.
In 1,000 feet, use any lane to turn right onto California 79 South, Beaumont Avenue.
Disputes often arise over changes or extras that are added or thought to be added.
Use any lane to turn right onto California 79 South, Beaumont Avenue.
Is to discuss change orders with the owner at the pre-construction meeting. Again, it all goes back to the same thing. Make sure you put as much as you can in writing. Please do that. That will prevent a lot of miscommunication between you and your client. And again, you want to detail out what labor, what services are you providing, for how much payment, and when are the payments supposed to be done. Now we're going to discuss arbitration. What is arbitration? One of the most basic ways to prevent a dispute is to put one in writing, so we kind of already covered that. But basically, what I want to really talk about in this portion of the paragraph, arbitration is like a court, right?
Continue on California 79 South for 8 miles.
Between you and the client and a mediator, which is like the judge. So what I want you to do at the bottom of page 22 is highlight the entire paragraph. Where it says arbitration, highlight the entire paragraph. Again, arbitration is like a court within the CSLB. It hears your side, the contractor side. It hears the client side, and the one in the middle is the CSLB. The CSLB will then try to determine who was at fault and try to find a solution that's best for both of you. Not just one side, but best for both of you. Unless the contractor was extremely guilty of fraud or something of that nature, they will still try to find the best solution for both of you. Okay? What do we have to know regarding arbitration? Now, technically, there's 2 versions of arbitration. What I first want to clear up is whether it's private or non-private. Private arbitration means that it was agreed upon when the contract was signed. So in a lot of home improvement contracts, at the back of the contract, there's a portion of arbitration. You explain to your client there, hey, if there's any problems during or after or before the contract or before the project is even done, instead of going to court and paying the court fees and hiring lawyers, One option we have is going directly to the CSLB and having them hear out our case. So instead of wasting money through the court system, we can go directly to the CSLB. Basically, we go directly to the State Department that issues my license. And again, the CSLB will try to find a solution that's best for both of you, and we'll try to find out who was at fault. The best thing about this is it's free. So why not take advantage of this? The CSLB arbitration program is free. All that needs to be done is your license needs to be in good standing, which means that you can't have a bunch of complaints against your license. So if your license is in good standing, you do qualify for the arbitration program, and it's free, which is the best part of it. If it's non-private arbitration, that basically means that the client contacted the CSLB directly to submit a complaint against you. They would mail out paperwork to your address. You would have to fill out the paperwork and return it within 30 calendar days. Now, what else do we have to know in regards to arbitration? I did say I wanted you to highlight the entire paragraph, because if it's mandatory arbitration, that means that only the client has the option to go or not go. So for example, if the client says, no, I don't want to go to arbitration, then you guys are going to court. If the client says, yes, we are going to arbitration, it doesn't even matter if you say yes or no, you're going to arbitration. So if it's mandatory arbitration, only the client has the option of saying yes or no. If the client says yes, whether you like it or not, you're going. If the client says no, you're going to court. And mandatory arbitration is for $15,000 or less. Mandatory arbitration is for disputes, $15,000 or less. If it's voluntary arbitration means that it's more than $15,000 but less than $50,000. And both parties must agree to go, which means the client must agree to go and you need to agree to go. So remember, mandatory arbitration is $15,000 or less. Only the client has the option of saying yes or no. If it's voluntary arbitration, both parties must be in agreement to go. And again, who are the parties? The client and the contractor. Okay, and then we're going to go ahead and go to page 23. There's a couple other things that I want you guys to focus on. On chapter 1, page 23, the very first paragraph, I want you to highlight the first paragraph in full, where it tells you that the CSLB provides and pays for the arbitrator. Who is the arbitrator? It's like the judge, the person that hears out the court case, and one expert witness in your trade. So for example, if the dispute is in regards to an electrical job that was done, then they would bring in an expert in the electrical field. If the problem was a plumbing job that was done, they would bring in an expert in the plumbing field. So remember, the CSLB will pay for the arbitrator, which is the judge, and one expert witness in your trade. Not only that, the CSLB pays all the administrative fees, which is basically like the paperwork fees. The CSLB will also pay that. However, the CSLB will not pay for any type of lawyer. So whether it be a lawyer, whether it be an attorney, right? Same thing. The CSLB will not pay for lawyers to represent any party. If you want to be represented by a lawyer, you would have to pay that out of pocket, and the same thing goes for the client. Okay, so now we're going to go ahead and move on to chapter 1, page 26. Chapter 1, page 26. In the very first paragraph, I do want you to highlight let's go ahead and highlight the entire paragraph, where it tells you, as a general rule, new construction, remodeling, alteration, and addition projects require building permits. Typically, non-structural activities such as painting, wallpapering, tile, carpet installation, cabinetry, and other work will not require a permit. Local building departments will keep a record of permits issued for work. So basically, rule of thumb, if the job that you do is structural, which means that you require permits to do that work, you have to obtain permits from the local building department. Electrical, plumbing, concrete, general construction, framing, those type of works or projects require permits. So you have to apply with the local building department, or you can even say the city. So I do want you to make a note next to, call it the last sentence, where it says local building department. You can also put city. Because let's say you got a question, where do you obtain permits from? Let's say the local building department is not an option. You can also choose the city. City would be a correct answer as well. Now, in the last paragraph on page 26, I do want you to highlight that paragraph in full, where it tells you after a building permit is issued, building officials may enter a residence for inspection purposes to ensure compliance with health, safety, and building codes, with or without the consent of the owner or occupants, on any day between 8 a.m. and 6 p.m. So this means they do not need your permission between
In half a mile, use the left 2 lanes to turn left onto Ramona Expressway.
They can just roll on up to the property. You would have to give them access, and then they're going to investigate for these codes, health and safety. The inspector may enter at any other times only with the consent of the owner or occupant.
Use the left 2 lanes to turn left onto Ramona Expressway.
Remember, the local building department does not need any permission from the owner, the occupants, or even the contractor between the hours 8 a.m. or 6 p.m. on any day. If they want to enter before or after these hours, then they need the permission of the owner or after obtaining a court order. Then we're going to go ahead and move on to chapter 1, page 28, where it says underground service alert. Chapter 1, page 28, where it says underground service alert. At that point, I want you to highlight, in the first paragraph, highlight the second sentence where it tells you, except in an emergency, every contracting firm planning to conduct an excavation must contact the appropriate regional notification center at least 2 working days before, but no more than 14 calendar days before. I know this is confusing for a lot of contractors, but make sure you take the note. You have to contact the USA, the Underground Service Alert, if you're planning on excavating anytime between 2 or 14 days before, which means you cannot contact them the day before, you cannot contact them 15 days before. It's between 2 and 14 days. I also want you to highlight the first sentence in the second paragraph where it tells you excavators must mark the area to be excavated before contacting the regional notification center by dialing 811. So it's very easy to contact them. So now we're going to go ahead and move forward to chapter 1.
Continue on Ramona Expressway for 2 miles.
Where it says Native American remains. I want you to go ahead and the first paragraph, highlight the first sentence where it tells you, if during excavation you unearth human remains or burial artifacts anywhere outside the cemetery, you must stop work immediately at that site and any other nearby area that you reasonably suspect to have remains. Please highlight that sentence. That is a question every single contractor will get at the state. I know it seems simple, but it's worded very carefully. So basically what they're telling you is the first thing you do if you were to unearth human remains is stop working immediately at that site and any other site. If you were to choose call the police, that would be an incorrect answer. Call the coroner, that would be an incorrect answer, because they're telling you what is the first thing you do. The first thing you do is stop working at that site and any other site. Then you would go ahead and contact the county coroner, right? So the first thing you do is stop working immediately at that site and any other site where you believe it might also contain remains. So that is chapter 1. Chapter 1 is a very simple chapter. It's an introduction to what the license is, the process of you getting the license, and some basic information. So if you feel like, oh wow, that was easy, just wait till we get to chapter 2, 3, 4. It does get a little bit more extensive, but chapter 1 is a great introduction to what we're doing. Remember, this is the class for the entire week. You have access the entire week from Monday to Sunday at midnight. Make sure that you read my emails, please. Some of the emails have a lot of great information.